My name is Matthew Midget with the Nye Law Group, and today I want to talk about the differences between military divorces and civilian divorces. In our practice areas that we have offices, both in Savannah as well as Hinesville, Georgia, we often have clients from either Fort Stewart or Hunter Army Airfield who call in and ask whether or not their divorce is any different because their spouse or themselves are active duty in the military. And the answer is yes, they are different. Initially, upon separation, there is something known as Army Regulation 608 that can take effect and allow the party who is the dependent to receive Army Family Separation Pay. And that's based on the BAH of the active duty soldier. If this does not immediately start from the active duty soldier, his or her chain of command can be contacted in order for it to occur. One thing that waives this obligation of AR 608 is whether or not you reside in on-base housing. If on-base housing is utilized, then AR 608 is not necessary to be paid, but it is an important support role that the active duty soldier is required to do for their dependents even when they are just separated and prior to divorce. Another issue that becomes very interesting in the area of military divorce is whether or not a person's military retirement is divisible. Now obviously a military soldier does not earn their retirement until they have at least reached 20 years of active duty service. However, their retirement is subject to division under Georgia law, regardless of the amount of time that the person has served in the armed services and regardless of the amount of time that the two people have been married. Many people have some preconceived notions about what the 10-10 rule means. And I'm here to tell you that it does not mean what you think it means. It is not a rule that forbids you from receiving any of your spouse's military retirement if you have not been married for 10 years or if he has not been active duty for 10 years. It is simply a payment structure that is facilitated after the active duty soldier's retirement, wherein you would receive the pay directly from a servicing center in Ohio. That's all the 10-10 rule means. In fact, the courts in Georgia don't treat a military retirement any differently than they would treat a federal pension or a state-earned pension. It's divisible, and there's actually a calculator that has been provided by the federal government that would help you determine, based on the number of months of your marriage and the number of months that coincide with the soldier's active duty service, in determining what percentage of your military retirement you may be entitled to. This doesn't stop a Georgia court or a judge from forbidding you to have any of the military retirement. Again, this all falls back on what is equitable and whether or not it is fair to divide that military retirement. So just because you may have a claim to it does not necessarily mean that a judge will award it.